Why in New York does it take 2 to 3 years for your medical malpractice case to get to trial? You want to know the answer? Come join me for a moment as I share with you the exact answer why. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's start from the beginning. You believe that your doctor was careless, causing you significant harm and injury. And now what do? You find an attorney who's willing to investigate your case. And now he gets all of your medical records and sends it out to a qualified medical expert. Your medical expert comes back and says, you know what? I do believe you have a valid basis for a case. Now you can go ahead and start the case. Did you know that in New York, if you don't have a medical expert confirm that you have a valid case, you can't start a lawsuit? It's true. Okay, so now let's assume that your attorney has gotten confirmation from a medical expert that says you do have a valid basis for a case. So your attorney goes ahead and prepares a document called a summons and a complaint. Now, those are allegations against the people whom you are suing, against the doctor or maybe even hospital staff. Your attorney has to prepare those documents and then file them with the court. Once they're filed with the court, that is the very beginning of your lawsuit. And what happens then? Well, now your attorney has to actually take those papers and actually deliver them to the people whom you are suing. There's a special person who actually delivers those documents. Your attorney doesn't take them and walk them over to the doctor and hand it to him. Instead, he uses somebody called a process server. Once that person has now delivered the documents to the doctor whom you are suing and to the hospital staff, you want to know what happens next? What happens next is that now the doctors and the hospital staff have to take those documents, the complaint, the summons, and actually deliver them to the medical malpractice insurance companies that represent them. So now they send it off to their insurance companies, and after a period of time, the insurance companies will go ahead and hire attorneys who are on retainer and to defend the doctors whom you are suing and the hospital staff. What happens after that? What happens after that is now the attorneys who represent these doctors and hospitals, now they have to review the documents, they have to consult with their clients to say, hey, what's this case about? What do you know about this? What information can you tell me involving Oginski's client? And now they will respond to the allegations. And did you know that when the attorneys prepare documents in response to our allegations, you know what that's called? It's called an answer to the complaint. And now they will deliver those documents to us. We will then read those documents, but in addition, they will also give us other documents that we have to respond to as well. One of those documents is called a demand for a bill of particulars. Now what's that? It's basically the defense attorney saying, hey, counselor, do me a favor. Tell me in detail exactly what this case is about. Why are we here? Why is your client bringing a lawsuit? What's the real claim here? What did the doctor do wrong? And what injuries did your client, the patient, suffer because of this wrongdoing? Did they incur any medical expenses? Were they out of work for a period of time? Were they unable to do their daily activities for a period of time? Please tell us. Tell us in detail. And so we have to respond to these detailed requests in a document called a bill of particulars. And in addition, the defense wants various documents from us. They want copies of your medical records. Maybe they want your tax returns if you are bringing a claim for lost earnings. And they'll want additional information, plus they will want permission slips to get copies of your medical records directly from the doctors and the hospitals where you were treated. And we are obligated to provide those to them. Okay, so what happens next? So now, once we have gone ahead and responded to those particular demands for those discovery items, now we notify the court and we say, hey, judge, just want to let you know that we would like a scheduling conference, please. Now, what's that? Well, lawyers call this a preliminary conference. It's the very first conference that the attorneys go into court. And what do we do there? We set up a discovery schedule. Every single case in New York has a very specific timetable that the courts want us to follow. We are obligated to follow that particular time schedule. Now, during this conference, the attorneys go ahead and enter into an agreement that says, listen, I agree to provide you certain documents within a certain time period. You agree as the defendant to go ahead and provide us with certain documents. And then, now we have to set up a schedule of when each of our witnesses are going to be questioned. We call that a deposition. It's a question and answer session that takes place in each attorney's office. And now, what happens after that? Well, we expect that each side is going to comply with those various requirements. But invariably, one side or the other does not. One side or the other may have a problem with what's being requested. And that could delay things significantly. What do I mean? So let's say the defense asks us for 20 years worth of your medical records. And we turn around and say, wait a second, you're not entitled to get 20 years worth of our client's medical records. And the defense says, yes, we are entitled to it. And now we have a dispute within your lawsuit, which is already disputed, right? So how do we resolve that? We have to resolve that by asking the court to resolve it. Either we ask the court to come in to go ahead and have a conference with the judge. The attorneys go into court, and now the judge will resolve this issue. Or the defense lawyer may formally request that the judge intervene and now take some sort of action. We call that a motion. Whenever an attorney makes a formal written request to the court to take action, to do something, they have to provide us with sufficient time to reply to their papers to the court. And then there will be sufficient time for the attorney to go ahead and respond to that as well. And after another period of time, the attorneys must go into court to now either argue this motion, or the judge will make the decision on the papers alone. And if the judge is going to go ahead and make a decision on the papers alone, now there's going to be a significant gap in time where it's going to take him maybe a month or 2 or 3 months to reach a decision on this motion. And you should know something. During that period of time, very little is happening on your case. Why is that? Because likely the defense will say, hey, wait a second. Everything else is held up for now until we get a real decision on this particular request. Now, that shouldn't really happen. All the other items should be exchanged, and now there should be no other discovery issues. But invariably, what happens is the defense attorney turns around and says, hey, I have to wait until I get a decision from the court before I go ahead and provide you with these other documents. So that could delay things significantly. Another issue that will arise is scheduling the various witnesses for their depositions. Now, you should know something. The attorneys get together, or I should say their calendar clerks get together to determine the availability of each attorney as well as the availability of the witness. If the attorneys and the witness can agree on a particular date, terrific, now we're moving forward. But there are many instances where somebody is not available. One attorney may be on vacation, another attorney may be on trial, and it may be impossible to schedule the deposition on the date that we originally agreed to during the scheduling conference. So what happens then? Well, we have to still move the case forward. These depositions have to take place, and we need this information in order to help prove our case. So now we must get this done. Now, let's say you are already scheduled for deposition. We now have to go ahead and schedule the doctors for their questioning. And here's something else you may not know. The defense often will refuse. They will refuse to produce witnesses back to back on the same day. So let's say you sued 3 different doctors. The defense attorneys will not willingly go ahead and produce 3 doctors in one day. They're going to argue a number of things. Oh, you're never going to finish in one day for one witness. That's why we need more days, we need more time. Or they may say, you know what, we want time to get the deposition transcript so we have an opportunity to review it before you question the next witness. And that's not an unreasonable request. When we schedule the doctor's depositions, we now have gaps in time. So the doctor may be scheduled for, let's say, March 1st, and now the next deposition after that might be March 31st, and the one after that might be April 15th. So there's going to be a gap in time when these various witnesses are questioned. That creates a significant delay. So let me share with you what happens after the depositions are completed. After they're done, we notify the court that the case is ready for trial. The moment we notify the court by filing a document called a note of issue, don't expect that your case is going to come up for trial the next day. The reality is that it won't. You know what's going to happen? I'll tell you what happens. What happens is that your case is going to sit on the trial calendar for the next 6 months, the next 9 months, the next year. Instead, what happens is that the attorneys get called in for a settlement conference. The judge wants to know whether or not there's a possibility or a possibility that your case can be settled before going to trial. And now he will often give the defense additional time to conference this matter with their insurance companies to get a definitive answer about whether or not they are interested in trying to negotiate this case. If they are, and there is the possibility of trying to settle this case before ever going to trial, the judge will allow the defense additional time. So that means your case is going to get delayed even more. There will come a point in time where the defense either says, listen, judge, we have no interest in trying to settle this case, or The judge says, listen, make a decision, counselor. Either you are going to settle this or not. If you're not, I'm setting this down for trial as a final trial date. And in that instance, now the judge says, fine, come back on June 1st. You're going to pick a jury on that date. And now your case will go forward, assuming you can't settle it. And now you will have your trial. So why do I share this great information with you? I share it with you because nobody else talks about this. This gives you a complete overview of exactly what happens in these types of medical malpractice cases here in New York. And I have something else to share with you. Just because it takes this long a period of time to get from the time you start your case up until the time you get to trial, that should not dissuade you from going ahead and evaluating your case. That should not dissuade you from going ahead and prosecuting a case. Why? Because if you believe that someone was careless, causing you significant harm and injury, you have an absolute legal right to try and obtain money as a form of compensation for all of the harms and losses and damages you suffered because of somebody else's carelessness. And one last thing I want to leave you with. The mere fact that you bring a lawsuit, there is the possibility that your case could be settled at any point from the time you start your lawsuit before trial. So the mere fact that it takes this long to actually get to trial doesn't mean your case cannot be settled early. Sometimes it can, sometimes it can't. Each case is individual. I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.